Morning, everyone, and thank you for joining us for Kenny and Sam's ongoing webinar series. I'm Ross Wecker, and with me today is Anthony Fioravanti, and we are going to be providing you with an overview of Mass General Laws, Chapter 254, the Massachusetts Mechanics Lien Law. So with that, we'll jump right into it and discuss generally what is a mechanics lien. A mechanics lien is a method of obtaining security for the value of work performed on a private construction project here in Massachusetts. Put another way, it's a method of making sure that the folks that work on construction projects get paid for the value of their work. That said, there's kind of three major things to look at when first analyzing whether or not you have the ability to file a mechanics lien under Mass General Laws, Chapter 254. The first, as I mentioned in the definition, is that mechanics liens only apply to private projects. So you're not going to be able to file a mechanics lien on a public job like a roadway project for the Commonwealth or a school for a local municipality. It will only apply to private work for a private landowner here in the Commonwealth of Massachusetts. So once you've cleared that hurdle and know that you're working on a private project, it's then important to determine which category of worker you would fall into and whether there is protection for that category. That's pretty well defined in the statute and is relatively broad as well. The categories that we generally deal with are the general contractor, the subcontractor, subcontractors, and material suppliers. There's also recently a provision for a mechanics lien by a licensed design professional. One area that you see coverage or coverage-related issues is if the contractor is somewhat too remote. That often arises in a situation where you've got a material supplier to a material supplier. If you're that far down the chain, oftentimes there's not going to be mechanics liens protections under the statute. So if you've met the requirement for a private construction project and you fall into one of the categories that I just mentioned, the third primary requirement to start the analysis of whether you can file a mechanics lien is determining whether you have a written contract. There is a written contract requirement, and when we look at that, talking about the categories that I just mentioned, we're looking for a written contract between the general contractor and the owner if we're filing a general contractor lien. We're looking for a written subcontract between a subcontractor and a general contractor if we're talking about a subcontractor lien, or we're looking for a written contract or purchase order between the material supplier and the subcontractor, or a material supplier and a general contractor if we're talking about one of those liens. Similarly, if you're looking to file a mechanics lien for a design professional, you would also need a written contract between the design professional and the entity for whom that design professional performed the services. There is also an additional requirement there that the design professional be licensed by the Commonwealth of Massachusetts to be able to enforce a lien. And there's very specific categories of design professionals that are licensed by the Commonwealth of Massachusetts. So if you have met those sort of initial hurdles, again, private project, you're in the category of folks that can claim a mechanics lien, and you have a written contract, then we can proceed with the process of filing a mechanics lien under Mass General Laws, Chapter 254. That process is very well defined within the statute. The courts of the Commonwealth have ruled that the mechanics lien is entirely a creature of statute and that you must follow the process set forth in the statute very precisely or run the risk of losing your mechanics lien. Some of the elements of that are strict timing requirements and some strict form requirements. They're all best handled by a experienced law firm that has filed liens before, so they make sure that there aren't any mistakes in the filing requirements, no missed deadlines that might otherwise cause you to lose your mechanics lien, as courts have repeatedly held that a small discrepancy in those filings, even missing a deadline by a day, can cause you to lose your mechanics lien, which can be very, very significant in losing your ability to get payment for valuable work performed on a construction project. So understanding that the statute must be strictly complied with, I will go ahead and turn to the first type of lien and walk you through the process for obtaining mechanics lien for a general contractor under Section 2 of Mass General Laws, Chapter 254. So as I mentioned previously, there is a requirement for a written contract. That in itself can be an interesting question of what constitutes a written contract for the purpose of filing a mechanics lien under Section 2. Best practice is obviously to have a formal written agreement covering the construction work to be performed, signed by both parties to the contract, so that there's no question that you've met the written contract requirement. However, often times, especially in today's electronic age, we don't see perfectly integrated written contracts like that. What we often see is a series of documents have gone back and forth, perhaps haven't been signed, but they do represent an agreement. We can also see email exchanges that largely constitute what the agreement is, but no final signed document. That does not mean that you haven't satisfied the written contract requirement. The written contract requirement is a little bit more expansive than a fully integrated and signed agreement. Basically, what you need to be able to show to establish that you have a written contract, which would support a mechanics lien, is written documents, including electronic emails that describe the work to be performed, identify the location where that work is going to be performed and the owner of that property, and have a method, at least a method of calculating the value of that work. So if you have a series of documents or one document that describes the work to be performed, the location, and the owner for whom that work is going to be performed, and the value of that work, you will likely meet the written contract requirement and will be able to proceed with filing a mechanics lien under Section 2 of General Laws, Chapter 254. Once you've satisfied that requirement for a written contract, there are essentially 3 steps to filing a mechanics lien in Massachusetts. The first of those steps is filing what is called a notice of contract. And that document is exactly what it sounds like. It is literally a notice of your written contract that gets filed in the Registry of Deeds. The document can be filed as soon as the written contract has been executed. You do not have to actually perform any work before the notice of contract can be filed, and it protects the contractor's potential lien rights in future work from the moment it's recorded at the Registry of Deeds. Generally speaking, it's not recorded upon the execution of the contract. In most instances, it's recorded later in the project at a time when a contractor is concerned about receiving payment for the work performed. In that instance, there is a secondary deadline that dictates how long a contractor can wait before filing the notice of contract. And the primary deadline for that is 90 days after the last date that work was performed under the written contract. So basically, once the contractor has completed the work under its contract, it has 90 days to file a notice of contract at the Registry of Deeds or risk losing its lien rights. The notice of contract itself is a rather formulaic document. The key aspect to it being a relatively detailed description of the property where the work was performed. That description is not going to be satisfied with a mere reference to the address of the property. Filing a notice of contract actually requires doing some research in the Registry of Deeds to identify deed references, potential plan references, and key documents such as that. And that's one reason that we definitely recommend that if you're going to take this step of filing a notice of contract, you have the title research and the document itself prepared by a qualified attorney who can also make sure that it's recorded properly at the Registry of Deeds. Once the notice of contract is recorded, the contractor is largely protected from the standpoint of now having an interest in the real estate where they're performing work. That document in and of itself does not trigger further deadlines unless the work has ultimately been completed. And by further deadlines, I mean the second step to perfecting a mechanics lien in Massachusetts, and that is the filing of a second document called the Statement of Account. A Statement of Account is similar to the Notice of Contract. In fact, some of the form language is virtually identical. The key distinction for the Statement of Account being, at least in Section 2, that it includes an actual breakdown of the value of the work performed, the payments that have been made to date, and the amount of money that is owed to the contractor, ergo Statement of Account. It's providing accounting information which largely sets the value of the mechanics lien. With respect to the deadlines surrounding the Statement of Account, it would not typically be a document that you would file at the beginning of the project. It would very much be a document that was filed later in the project at a time when money is owed. And it itself also has a deadline that can correspond somewhat to the notice of contract, but is also triggered by the last date that work was performed. Generally speaking, that document needs to be filed within 120 days of the last date that work was performed under the general contract, which would correlate to 30 days after the notice of contract. If it's not filed within those timeframes, again, you'd run the risk of losing your mechanics lien. After the Statement of Account is filed, it sets another very firm deadline under the statute for ultimately filing a lawsuit to enforce the mechanics lien. So after the Statement of Account is filed, you have 90 days to file a lawsuit in the Superior Court to enforce, the Superior Court or District Court where the land lies, to enforce the mechanics lien. The complaint is definitely something that you're going to want to have a lawyer involved in preparing and filing. And once it is filed within that 90-day period, it needs to be certified, and then a certified copy of the complaint also needs to be recorded at the Registry of Deeds. If any of those deadlines are not met, the filing of the complaint, the recording of the complaint at the recording of a certified copy of the complaint at the Registry of Deeds, you again run the risk of losing your mechanics lien to what would often be perceived as a minor defect. But again, courts have held that it is critical to follow and meet those deadlines and all of the steps to perfect that mechanics lien. So again, we certainly urge, when you're into those aspects of filing a mechanics lien, you utilize the services of a qualified attorney to prepare the documents and to do the title research necessary to record those documents. It should be mentioned that there are two other potential timing issues with mechanics liens, although they rarely come up. Those are dates that run from the filing of a document called a notice of termination or a notice of substantial completion. Both of those are documents that are, generally speaking, filed by the owner, can be recorded at the Registry of Deeds, and would be something that a contractor receives from the owner. Without going into unnecessary detail, if you receive or become aware of a document called a notice of termination or a notice of substantial completion, you should reach out to an attorney to analyze what the timing implications of those two documents are on your ability to file a mechanics lien. Understanding that there are some strict deadlines associated with this, it's important to also note, what does the date of last performance mean? It does not necessarily mean the last day that you are on the job. It is the last day that you performed work under the contract for which you would normally receive payment. It does not extend to warranty periods. So if you've completed your project, left the job, got a call back to do warranty work, that is not going to extend the 90-day period. The 90-day period would run through punch list as long as you've not yet received final payment and you've somewhat continuously been doing work out there to try and complete the punch list. But it is important not to wait on that 90-day period using warranty work as the last day that you were out performing work. One final key distinction to the general contractor lien versus what Anthony will speak about here momentarily on the subcontractor lien is that in instances where the interest in real property is subject to a lease, the general contractor actually can get a lien on not only the leasehold interest, but also the fee interest, provided the general contractor can show that the landlord knew of the construction. This can be a significant benefit to a general contractor in that oftentimes leasehold interests terminate or are invalidated by the mere recording of a mechanics lien. And the security provided by a mechanics lien against a leasehold interest is simply not as good as it is against a fee interest. So that's the general overview of a General Laws Chapter 254, Section 2 General Contractor Lien. It has many similarities, as you'll hear from Anthony in a moment, to the Section 4 lien. And at that, I will turn it over to Anthony to discuss the remaining aspects of our lien law.
Thanks, Ross, and thank everyone for joining us this morning. As Ross said, I'm going to discuss the particularities and nuances of a Section 2 lien as opposed to a Section 4 lien. And Section 2 liens cover subcontractors and sub-subcontractors and material suppliers. So folks who don't have a direct contractual relationship with the owner of the project, but instead have a direct contractual relationship with the general contractor, or in the case of a sub-subcontractor, they have a direct contractual relationship with a subcontractor on a project. As Ross said, or as applies to Section 4 liens, with Section 2 liens, a written contract is required, and the relevant written contract here is a written contract as between the subcontractor and the general contractor. And in the case of a sub-subcontractor, again, the written contract requirement is as between the sub-subcontractor and the subcontractor. And the same requirements for a written contract, or the same standards that apply to a written contract in the Section 4 context with general contractors, apply here as well. I'm going to talk briefly about the nuances for a subcontractor, and then some additional nuances and particularities for a sub-subcontractor. So first, with respect to a subcontractor, once again, a subcontractor is required to file a notice of contract with the Registry of Deeds. But there are some differences in the subcontractor notice of contract from the general contractor notice of contract. Generally speaking, as for timing, the timing for a subcontractor to file a notice of contract does not run from the end of that subcontractor's particular work, and instead it extends to the last time the general contractor performed work on the project. As an example, if you are a site work contractor and you perform your subcontract work at the outset of the project and you're complete and finished within 3 months of the project starting, but the project extends thereafter for another year, the time for you to get your notice of contract on file extends for that whole 1-year period. It does not end once you complete your subcontract work. And again, it's 90 days for a subcontractor to file its notice of contract after the general contractor performs its contract work. Now, the notice of contract that a subcontractor is required to file is a little bit different from the notice of contract that a general contractor is required to file. The Section 4, general contractor notice of contract, is fairly generic. It includes as Ross said, identifies the property, identifies the project, and has particular deed references. A subcontractor, in addition, has to include some project accounting. The amount of the initial contract that the subcontractor had, the amount of agreed change orders, the amount of pending change orders, the amount of disputed change orders, and some other requirements are included in the notice of contract that a subcontractor files. There is, in fact, a statutory form under Section 4 of the Mechanics Lien Statute, and the best practice really is to follow that form because, as Ross said, the courts really strictly interpret the Mechanics Lien Statute, and if you misstep, it could be fatal to your lien rights. So when you have a subcontractor situation, there's a standard form in the statute, and the best practice is to follow that statutory form. Additionally, whereas when a general contractor files a notice of contract, it establishes its lien rights at the outset. A subcontractor's lien rights are not established until the subcontractor sends a notice to the actual property owner that it has filed a lien. So if a subcontractor has a contract with ABC General Contractor, files a lien, they also have to notify the property owner, hey, I've got a lien on your property, and their lien is not valid until, quote, actual notice is received by the property owner. Actual notice is not defined in the statute, but the best practice here is to use some form of delivery that requires a signature or some confirmation of receipt, because if there is a dispute down the line in court, you want to be able to establish that you indeed provided the actual notice required under the statute. So that's for subcontractors. In contrast to general contractors, you have to give actual notice to the property owner. Unlike where Ross said a general contractor, if they enter into a contract with a tenant, a lessee, they can obtain a lien on the fee simple interest, the property as a whole. A subcontractor cannot do that, and instead a subcontractor's lien rights are limited to the leasehold interest. So if, for instance, XYZ Plumbing enters into a contract with ABC Contracting for a tenant that leases 4 floors of a 10-story building, when XYZ Plumbing establishes its lien rights, it is limited to those 4 floors of the building on which it actually performed work and doesn't have a lien on the entirety of the building, whereas ABC Contracting could. So that's an important distinction because it limits in some ways the rights that subcontractors have. One other item of note for a subcontractor notice of contract, a subcontractor's lien rights are limited to the amount that is due or to become due to the general contractor at the time that its notice of contract is filed. So if, for instance, a subcontractor files a notice of contract at the very end of the job after all work has been performed and the general contractor has been paid in full under its general contract, the subcontractor essentially loses out on its lien rights because there is no amount due and owing to the general contractor from the project owner. So one would think that it's the best practice for a subcontractor to file a notice of contract early. However, and it seems that would be the case, but because a subcontractor filing a notice of contract can impair financing for a project, banks who are funding the project and who have a mortgage on the property as security for their financing of the project, when their security can be impaired by a notice of contract filed by a subcontractor, it can disrupt financing on the project and cause issues for the general contractor, cause issues for the owner, and is generally considered, a quote-unquote act of war. And it's something that a subcontractor wants to carefully consider before filing a notice of contract and should consult with counsel about before filing a notice of contract. So that's the Section 4 lien for a subcontractor. There are additional requirements for subcontractors and material suppliers that I will briefly mention. Again, you've got the same requirements and limitations as a subcontractor lien. You need a written contract with the subcontractor. In addition, a subcontractor or material supplier to a subcontractor should provide what's called a notice of identification to the general contractor. This is, again, a statutory form. It lays out what you should include in a notice of identification. And the purpose of the notice of identification is to let the general contractor know that you, the material supplier, or the subcontractor are providing either labor or materials to the general contractor's subcontractor, so they know that you exist. And if there are payment issues that arise, the general contractor can try to deal with them. If you file that notice of, or if you send that notice of identification at the outset of the project, it preserves your lien rights on the amount due or to become due analysis. So it is a best practice for subcontractors and material suppliers to send that notice of identification at the outset of the project. It does not impair financing. It's not the quote unquote act of war. It's just identification to the general contractor that you are working on this project or providing materials on this project, and at some point down the line may be looking to get paid. Now, those are the requirements for a Section 2 lien and a Section 4 lien. As Ross said, these are exacting standards that have to be met in order for you to preserve your lien rights and to have enforceable security in the event of a payment issue. Now, what happens if you don't meet those requirements for whatever reason, or you cannot meet them for whatever reason? Well, there are alternatives to the mechanics lien to provide security to a contractor in the event that there is litigation. Whereas a mechanics lien provides you security as a matter of right. If you check all the boxes that we've discussed, you establish a mechanics lien. If you can't meet those requirements, there are options in litigation to request security from the court, including a real estate attachment, where you ask the court to grant you an attachment on a particular piece of real estate. There's a trustee process attachment, where you can obtain essentially a lien on a bank account of the party that owes you money. And in some instances, there's also what's called a reach and apply attachment, which allows a creditor to reach essentially accounts receivable that the debtor owes to the creditor. So if you can't meet those exacting standards that we've discussed today, but you are looking for security for a claim that you have against your contracting party, there are alternatives that may be available to you. So you keep that in mind as you move forward in the dispute resolution process. And with that, I'll turn it back to Ross.
Thank you, Anthony, for that good discussion of subcontractor and subcontractor liens. And thank all of you for joining us today. Hopefully you found this overview of Mass General Laws, Chapter 254, the Mechanics Lien Law, informative. This is, I believe, now our fourth webinar, and we will be continuing to do these. We have 2 upcoming webinars. The next one is on November 18th, and it is on understanding key insurance provisions, followed by another one on December 16th that will address some timely and hot employment topics. Again, we thank you for joining us today, and I hope you found this informative. If you have any questions or want to discuss mechanics lien rights, please feel free to reach out to Kenny and Sam's, and we are here to help. So thank you very much.